Good afternoon and welcome to the Village at Augsburg. This is our elder law webinar series, and today is part 2 in our series. It's a really important topic, and I'm delighted that we're going to have Stacey Rogers with us from Frank and Share Law Firm. She is going to talk all about Medicaid and answer questions, which I hope you have some to share with her. But before we get started, I do a little bit of housekeeping and I want to give you a little bit of introductions. My name is Suzanne Roos and I am the sales director here at the Village at Augsburg. A lot of you have joined us in the past for other webinars, and you have usually been greeted by Adrienne Brown before I come on the screen. And Adrienne is our sales coordinator and she's on vacation this week. So I am filling in some big shoes. She always does a great job as our moderator and host. So just to get you familiar, if you're new to this webinar, it is being recorded. So you will be able to watch it again if you miss something, if you can't stay for the entire hour. We put it on our YouTube channel and we will send you a link to that next week. That's one of Adrienne's tasks when she comes back from vacation. All of our participants, we can't see you today. Your cameras are disabled, as are your microphones, but you are welcome and encouraged to submit questions. At the bottom of your screen, you'll see a little Q&A area, and if you drop your questions into there, I will be watching for those while Stacey is giving her presentation. And as I said, feel free to drop those in there as we go. If you want to hold your question till the end of the webinar, that's fine too. I find sometimes it's easier when you're thinking of something, especially if it's right on the topic, to just ask that question then and we can get it addressed for you. We try to keep this to about an hour. Sometimes we're a little bit less than an hour and sometimes we run over a little bit. So we appreciate your patience and flexibility with us on that. And that's pretty much our housekeeping for the webinar. Again, I'm the sales director here at Augsburg, and I know that a lot of you have visited in person or have attended webinars, but there are some new people joining us today. So I want to welcome you and thank you for spending some time with us. Augsburg is a continuing care retirement community. And so it is a place where seniors usually come to live and spend the rest of their life. We do offer a continuum of care that starts with independent living, and we also have assisted living, short-term rehab, and long-term care all on our campus. All of you will be continuing to receive invitations to future webinars. You can also always follow us on Facebook and look at our website anytime to see what events are coming up. We're getting ready soon to have some in-person events again, and I hope that you'll consider coming out. And if you don't feel comfortable, coming to an event, you are always welcome to come for a personal tour. If that's something that you're interested in, you can reach out to me anytime. And again, thank you for spending some time with us. And so now I am going to turn over today's presentation to Stacey, who's going to start by giving you a little introduction about herself and her experience, and then she will share her screen and start her presentation. So welcome, Stacey.
Hi, everybody. Good afternoon. I hope you all can see and hear me. So as Suzanne said, I'm Stacey Rogers. I'm an attorney at Frank and Share in Baltimore. We primarily practice in the field of elder law. What I typically do in my day is Medicaid and asset protection planning, as well as estate planning. So wills, trusts, powers of attorney, guardianships when those documents have not been created, probate, and estate administration. So some of those areas will be touched upon in relation to the Medicaid planning. So feel free to ask questions about how those intersect with what I'm going to be talking about today. We're going to address why someone might need Medicaid, how they're going to become eligible. There are different components to that eligibility requirement, as well as some planning options that you can look at if you're faced with the need to apply for Medicaid and long-term care. So feel free to ask questions. I told Suzanne she can interrupt me if necessary. If people have questions about a particular topic, don't be shy, or you can wait to the end.
Yeah. I'm sorry, I just wanted to a lot of people may have gotten an invitation in the mail, and Stacey wasn't in that original invitation. It was Rachel, who was here last week, and Rachel's in court today. So Stacey graciously stepped in. This is an area of expertise for her. So I'm really grateful that she could, everybody had to pivot to get here today. So thank you again, Stacey, for that. And we will make sure that we send you Stacey's contact information when we send you the link for the webinar, so that if you do have questions that you want to reach out to her about privately afterwards, you will have that information.
Yes, absolutely. So I'm going to share my screen. It's a PowerPoint presentation. We're going to go through it to discuss the various aspects of planning for Medicaid. I'll try to be clear and go through each slide. If you need me to go back for something, let Suzanne know. So bear with me while I share my screen. All right. So this is my contact information if you want to quickly write it down, if you need to reach out to me for anything in particular that you don't feel like bringing up or sharing today. That's my email, phone number, website. All right. So if you're faced with the need to go into long-term care setting, which the majority of Americans may need to go in the future because the life expectancy is now, continues to increase with advances in medical science and technology. You may be asking yourself, how am I going to pay for this? The average cost of a nursing home is between $10,000 and $12,000 a month, and it continues to increase. And depending on what your care needs are at that time, may far exceed those estimates. Living at home in the community and paying for private duty aids could far exceed that amount as well. So you're having to grapple with, how are my finances going to afford me the options that I may need in terms of what your health situation may present at the time. So you've been saving your whole life. How is that going to be used to pay for your care? When it comes to a nursing home or assisted living, your options include the option of privately paying, whatever that daily or monthly rate may be. In a nursing home setting, though, you may also have the option for qualifying for public benefits. So what I'm going to talk to you about today is long-term care medical assistance, otherwise known as Medicaid, which can be a payer source if you qualify and meet the criteria, both medically and financially, to cover those costs. So some people may have long-term care insurance or may have considered this in the past or present. This is also a source of funding when it comes to paying for your long-term care needs if you qualify medically. Now, this may or may not cover the full cost of your nursing home care if you are otherwise medically eligible. So you still may be facing the need for medical assistance or Medicaid, even if you have purchased long-term care insurance to cover the cost of the nursing home. So when you're first entering a nursing home, you may be entering from a hospital setting as opposed to coming from the home or the community. You may initially receive Medicare benefits to pay for this cost. Now, some people think Medicare may pay for the entire stay and if you need that type of skilled care, but Medicare after a hospitalization only covers a small portion of your stay if you're going to be living there long term. The first 1 to 20 days are fully covered by Medicare, but after that 20th day, there's a copay per day that you're going to be paying the nursing home if that's where you're residing. If you have supplemental health insurance, that may cover that copay, or you may be facing this copay out of pocket. Now, Medicare is only going to pay for your nursing home stay if you meet the level of care that requires you to be in that setting. So not everyone qualifies for these full 100 days. It could be just the 20. It could be anywhere in between 1 and 100. So you have to consider how you're going to pay if you need to stay in this setting after Medicare coverage ends. So immediately after you're discharged from Medicare, you're going to be looking at a private pay cost, which is often daily. That can be $300 a day and go up from there depending on what level of need you have at the time. So planning ahead of time for what will happen when Medicare coverage stops, and you may be facing a long-term stay at a nursing facility, both either for months, years, or indefinitely, is very important. So you're not faced with the harsh reality of a large bill that's going to be slipped under your door, perhaps, or given to your family member after Medicare coverage ends. The other option, of course, is if you are able to return home, then we're not going to be looking at Medicaid. But if you need to transition from a rehab setting, let's say, where Medicare is going to cover your cost, to a long-term stay, that's what we're going to be talking about today. So if you can't afford private pay, the $300, $400 a day bill you're going to be faced with, then you may want to be talking to an elder law attorney about how and when you can qualify for Medicaid. Medicaid will pay for the room and board at the nursing facility, as well as most medications that you have and doctor's bills. So instead of paying the $9,000, $10,000, et cetera, per month, you can qualify to have the state government assist you with paying for those expenses, so you're not having to hemorrhage all of your hard-earned money to pay the nursing home, which who knows how long that will last, if you're looking at a bill of $10,000 a month for the indefinite future. But to qualify for Medicaid, you're going to be looking at strict medical and financial requirements that have to be met prior to becoming eligible and then ultimately applying for Medicaid benefit. So we're first going to talk about the medical criteria. This often in my office, we need to address first, because if you're not going to meet this criteria, then we don't even talk about the financial component. We don't want to spend your money, spend you down for eligibility purposes, unless we're sure that you're going to meet medically. Clients will come to us either already in a nursing home or perhaps from the home, and we first evaluate what their care needs are before proceeding to discuss what their options may be in terms of a financial plan. So the medical eligibility standards are this. You need to be in a nursing home. Assisted living will not accept Medicaid in the majority of circumstances. There are some other public benefit options you may have in the future. We're not going to be talking about that today, but you need to be receiving and needing skilled nursing services. How Medicaid defines this is hands-on assistance with 2 or more activities of daily living. So what does that mean? Bathing, dressing, mobility, toileting, eating. This does not mean that you need to be reminded to do these things, but actually need someone to help you accomplish these tasks. Medicaid is also going to look at instrumental activities of daily living, telephone use, money management, medication administration. Those in and of itself aren't going to qualify you for Medicaid, but it's a piece of the puzzle to determine if this is the appropriate care setting for you. They're also going to look at your behavioral issues. Do you wander? Are you hallucinating? Are you aggressive? These are all calculated into a metrics to determine whether you're going to meet that minimum standard to qualify. Now, if you're already in a nursing home, the facility may advise you or your loved ones whether they think you'll meet this level of care. But if you're coming from home, you may not know this or have anyone assessing you to determine if this is something you're going to meet. So often my clients will engage either a geriatric care manager or visit a facility to be evaluated prior to deciding to be admitted to see if they're going to meet this level. Because if you don't need the nursing home care, both financially and otherwise, you're not going to want to be in that setting. And once you're admitted, you're incurring this large bill. So you want to be sure that that's the appropriate place for you to be. Now, There is a company that will ultimately evaluate whether you meet or don't meet this level of care. It's a form that the provider, so either that care manager group who's going to be assessing you privately or the nursing home, they're going to complete a form called a 3871B. That will evaluate on a level of 0 to 4 how much assistance you need with certain activities in terms of functionality, as we just discussed, bathing, eating, dressing, etc. This form is then sent to a company called Telegen, who has a contract with the state, who ultimately says yes or no. When my clients come to me and we're not sure, we'll often get that form completed, send it to Telegen, and ask for an advisory opinion before we even take that next step about whether nursing is the right option for them or not. Like I said, you don't want to go there if you're not needing to go there financially and otherwise. So we don't want to start that process, both with engaging us, spending money on those services, but also if a step down option is more appropriate for them, then maybe that's where the conversation ends and we can readdress it if their health declines in the future. All right, so that's the medical component and piece of eligibility, which again, we want to take care of first. Now, your health and needs may fluctuate and change over time. You need to remember that you have to consistently meet that level. Even if you meet that level on initial blush and you're admitted to a nursing facility, you have to maintain that need throughout time. If you improve, there is a possibility that even if you're receiving Medicaid, you then may be denied in the future if you improve and no longer need that service. All right. So now we're going to be looking at the financial component of Medicaid after we've had the medical side taken care of. So we're going to be looking today at income and resources. All right. So the first step is an eligibility of income. Your income must be less than the private cost of the nursing home. If you have an excellent pension and Social Security and investments that are giving you dividends each month and maybe trust income from a trust set up by a grandparent years ago, and it's more than the nursing home's going to cost you, you're not going to qualify for Medicaid. And I'll explain how that works, but you're not going to be able to use this resource because you can pay for it yourself. Some states have an income cap, just a dollar amount that you will or will not qualify for. But in Maryland, it's based on if it's more or less than the private costs at the nursing home. The reason for this is because when you're on Medicaid and receiving this benefit, you also have a financial contribution obligation. The state is not going to pay for 100% of the services. So if the nursing home costs $10,000, Medicaid's not going to be paying $10,000 a month for your care should you be eligible and qualify and receiving the benefit. Rather, your income minus allowable deductions will be paid as your contribution to your care to the nursing home each month. Medicaid will then pick up the rest of the bill based on a daily rate that Medicaid is allowed to pay. The reimbursement rate's a little different than a private pay cost, but for intents and purposes of this conversation, just to illustrate how that would work, if the nursing home cost is $10,000, your income minus certain deductions is $2,000, you're going to be paying $2,000 a month. Medicaid pays the other $8,000. So that's why the income has to be less than the private pay cost, because if your income can satisfy that, there's no place for Medicaid to pick up the rest of the bill. Now, what are allowable deductions? So from your gross income, not net, this is not the amount that you may see in your checking account when it's deposited from Social Security. We're talking about actual gross income. You're allowed to pay your Medicare and other health insurance premiums. And in most cases, that's the only deduction that you're going to be allowed, plus an $84 personal needs allowance. The $84 changes typically annually, maybe increases $1 every year, but it's not set in stone how that works. The $84 is used for things that Medicaid doesn't cover: clothing, television, certain other medical expenses like over-the-counter drugs or a podiatrist, or things that Medicaid's not going to pay for. There are also certain allowances that if you have a spouse living in the community, they may be entitled to a portion of your income with certain qualifications if their income is low and is below a threshold that is set by Medicaid, which again changes periodically. The current amount is $3,259.50 as of this past July. So in certain circumstances, a spouse living in the home or the community can receive your income to bring their income up to that $3,000 mark. It doesn't mean they're going to get $3,000 from you. It's just whatever their income is, it may allow them to be brought up to the $3,259. There are other deductions that some people may qualify for, including residential maintenance allowance to pay for the upkeep of a home that you may own, pre-existing medical bills, and family allowances if you do not have a spouse under certain circumstances. So what you're going to be doing is when you're working with my office or another, or your family, you're taking gross income, deducting these certain allowances minus the $84 and coming to a cost of care. That's the responsibility you as the Medicaid recipient has to pay to the nursing home every month.
Stacey, I do have a question.
Absolutely.
And you haven't specifically mentioned this yet, but what if someone qualifies for Medicaid, but the monthly income, pension, and Social Security is more than $2,500 per month?
Okay, great question. So the $2,500 a month is a resource limit. It's not an income limit. So we'll be touching upon this in a couple of slides from now, but your resource limitation is only evaluated at the last moment of the last day of the month, or alternatively, the first moment of the first day of the month. Your income can fluctuate throughout the month. So let's say you have $2,000 in your account on the 1st of September. Your income comes in on the second day of $5,000. You're allowed to be over that $2,500 throughout the month. From that $5,000 income deposit you've received, a vast majority of that's used to pay for your health insurance and the nursing home cost of care. You're only keeping $84 per month from your income. So unless other expenses are paid, you started with $2,000, $5,000 came in, you're only keeping $84. Theoretically, by the end of September, you may only have $2,084. That's how you get below the $2,500. Okay. Medicaid's not looking at what happens on the 15th of the month. They're only looking at the last day and the first day.
Very well explained. I have another question.
Yes.
Is premium for long-term care insurance an allowable deduction counted as health insurance premium?
No. But I will, let me clarify in terms of income and deductions. We're only looking at the applicant's income. We're not looking at the spouse's income. So if you're married and your income is less than the nursing home cost, but let's say your spouse living in the home has a lot more income than you, that's irrelevant. That your spouse can still pay for certain expenses that you may have, the home, long-term care, et cetera. So I wanted to clarify that we're only looking at the actual applicant. But no, in my experience, long-term care insurance is not something that's being deducted.
Thank you.
All right, so let's talk about eligibility rules and financial requirements for married couples as well as individuals. The rules and the strategies that we implement are going to be very different. So for a couple, so individuals, one spouse is living in a nursing home and has, complex medical needs. The other spouse is living at the home or somewhere else in the community. You're going to be looking at gross assets of the couple combined. Medicaid considers them to be a unit. It does not matter yet who actually owns the assets, whether it's husband or wife and vice versa, and which one has the need for Medicaid. They're looking at the couple as a unit, and they're looking at what their gross countable assets are. We're going to be talking about what is countable as far as Medicaid's view and what's excluded for qualification purposes, but think of the married couple as a unit. And as a unit, they're only allowed to keep a maximum of a certain amount of money. Now, this amount that the community spouse, the one living in the home, is allowed to keep, again, just like the other numbers I've reported, varies from year to year. The current allowance for a community spouse is $130,380. That's the most that the spouse living in the community is allowed to keep for the nursing home spouse to be financially eligible. Now, how do we determine how this number is derived and how much of that spouse is able to keep? We're going to be talking about next, but that's the maximum. It doesn't mean every situation warrants that spouse can keep that amount. We have clients that can keep less than that, but no one can keep more than that. Okay, so as of January 1 of this year, the community spouse can keep half of their countable resource that existed as of a community spouse resource allowance date up to a maximum of $130,380. What does that mean? So Medicaid's going to look at the first day of the first month in which there was at least a 30-day stay in a long-term care facility. That could be rehab or just coming in from the home and the community to need nursing home care. They're going to be looking at that very first day of the month, how much you and your spouse had combined. The amount the spouse in the community can keep is at a maximum 1/2 of that amount. So if you're entering the nursing facility and your spouse is at home and you're entering in August 1st, let's say, and you combined had $500,000, you're going to cut that in half to the $250,000. Well, that's far more than you're able to keep. You're still only allowed to keep the $130,000. We're going to be talking about today how you spend down to $130,000, because you can't keep more than $130,000, even if you had more than double that as of your first day of the first stay. Now, if you have less than that, let's say you only have $100,000 of countable assets on that first day, half of that's $50,000. That you're allowed to keep with a straight, calculation of 1/2. There is a minimum if you have fewer resources than that. The minimum is approximately $26,000 currently. So there's a ceiling and a floor as to how much the community spouse is allowed to keep. Now, if you had a prior stay in a rehab facility several years ago, that's going to count in determining how much the community spouse is allowed to keep. So it's going to be very critical in documenting what types of stays you may have had in a nursing home over the years. I've had clients who first entered a facility 2, 3, 10 years ago. We have to look at the first day of that month in that year in evaluating what 1/2 is. You may have had far more resources 5 years ago or 1 year ago or 1 month ago than you do during this day, but that's how Medicaid captures how much you're allowed to keep. I also have some clients that did not have a prior stay in a nursing facility. So we don't know what the maximum they can keep until they actually enter a facility. That is going to play critically into how and when we're able to spend down and qualify for Medicaid. If someone comes to me and they've already had a prior stay and I know they can keep the maximum, then we can get started on a Medicaid plan very quickly. You may, in some circumstances, be able to enter the nursing home already financially eligible for Medicaid. So it's possible you may not have a private pay bill to the nursing home at all because we've qualified you and spent you down to the threshold of below $130,000. Alternatively, if you've not had a prior stay and we don't know that calculation, you do not want to spend down ahead of time because that will ultimately decrease what you're able to keep. So the sooner you're able to identify the nursing home need and then speak with an elder law attorney as to what options you have and the timing, the better, because we can plan into place relatively quickly. So if you have a prior stay or not, we can get you eligible within, immediately up to maybe 1 or 2 months. So the sooner you talk to someone, the better, so we can best plan for your specific scenario. All right, so how do you spend down? We have that scenario of you had $500,000, you cut that in half to 250. The most you can keep is 130,000. We're looking at having to spend at least $119,000 before this couple is eligible for Medicaid. Now, that does not mean you have to pay the nursing home for, let's say, 11, 12, 13 months to get that spent down in the literal sense. But there are some strategies that we can implement so you can save and protect a good portion of that money, if not all of it, in a spousal Medicaid case to get you eligible. So if you're concerned about having to spend all of your money before getting qualified for Medicaid on the nursing home itself, that's not the case. So some of these planning tools we offer to our clients as ways to spend down so they're not faced with large bills in the future, because the nursing home spouse is using their income to pay their cost of care. A lot of times my clients who are in the community say, well, I was relying on my husband or my wife's pension to pay for my home, to pay my mortgage. How am I going to keep doing that if I'm only relying on my income? So paying some of their household expenses as part of the spend down is often helpful to get rid of those big bills so the community spouse can be comfortable and also not impoverished. So some of these options are paying the nursing facility. Like I said, depending on when they enter and when they start this spend down plan, they may have 1, 2, or more months of a nursing home bill, private pay that they're faced with. Other medical expenses they might have, prior hospitalizations or doctor's visits. If they have any debt, we strongly advise paying that down to the extent possible, credit cards, mortgage, car loan. They can also do repairs to their home. Keep in mind, though, that repair would have to be completed before you apply. So that doesn't always work in a lot of situations since we move relatively quickly. It's typically a crisis that you're facing and you want to make sure you can get Medicaid as fast as possible. So that works in some cases, some doesn't. If the community spouse needs a vehicle or other types of appliances or things for the home, another good option for spending. Funeral trusts. That's an excellent planning tool because unfortunately, we're all going to have to be facing this at some time in the future. Better to have that taken care of now when you have a pot of money you need to spend to qualify for benefits. So we frequently recommend to clients an irrevocable pre-need funeral plan or cremation and burial. One, so your loved ones don't have to face that decision on your behalf in the future, but also the amount you're spending, there's not a limit. And all of that is not countable for Medicaid. So I have clients who, purchase $10,000 or $12,000 or $15,000 funeral trusts for both of the spouses to quickly spend down a large sum of money. Now, the last option of what we do in our spousal cases is an actuarially sound annuity. This is the greatest tactic we employ to protect all of your money. What we're doing is we're converting your resources, so your accountable assets, from cash to an income stream. You may recall when I mentioned, when Suzanne asked me a question about spouse's income living in the community versus the nursing home spouse, the Medicaid's not going to care how much income the spouse in the community has and continues to generate wealth. So we recommend a single premium immediate annuity for our spousal cases as a way of converting a pot of money into an income stream for a period of time. So the $100,000 we have to spend down, we convert it to, let's say, a 2 or 3 year annuity term, and you're going to be splitting up that $100,000 over 24, 36, et cetera months. The caveat with this tactic is that the state of Maryland is the primary beneficiary should the annuitant pass away before the annuity is finished paying out. So this is something that we would employ for the community spouse, not the nursing home spouse. We don't want the nursing home spouse to be receiving all of this income over time because that would go into how much they have to pay the nursing home. We're doing this for the community spouse's benefit because that way we're spending from, let's say, the $200,000 to the $100,000 they're allowed to keep, they'll get paid back over time, that $100,000 they're putting into this annuity vehicle. So you'll have monthly fixed income payments. The term that you ultimately decide, how long the annuity pays you back, depends on your life expectancy. There are life estate tables to determine, based on your age, how long your annuity could be for. But because the state is the first beneficiary, we want to have it be as short as possible, so you get paid back as quickly as possible. So you're not having that money, structured in such a way where it's likely that you could pass away before it's finished paying out. This annuity has to be irrevocable, non-assignable, non-surrenderable, and there's no cash value. So once you've implemented this piece of the plan, you can't undo it. So what we would do in this type of situation is we would transfer all of the assets to the community spouse. So the nursing home spouse has that less than $2,500 limit. Everything else goes to the community spouse. And from there, we're going to spend down by potentially purchasing this type of annuity. So if there are any questions about how that works, I can pause for a second, but then we're going to talk about individuals and how individuals would qualify.
Stacey, there are two questions. They're not specifically related to this, but I do want to just put them out there so we haven't forgotten them. The first one is there an age limit to a long-term coverage policy?
That I do not know. It's going to depend on pre-existing health conditions, whether you qualify. So there are components that they're going to look at. The premiums could be extraordinarily high, depending on your age and your health, but I do not know the answer.
And here's the second question. What are the exceptions for Medicaid to pay toward assisted living? What are the needs that qualify for skilled nursing? Apparently, it is not the ADL needs, which is a separate criteria.
So in my practice, we don't qualify individuals on the assisted living side because that's going to be covered by what's called a Medicaid waiver plan, which if you're just signing up, there's a very, very long wait list. It could be 7 or 8 years before you come off of that, before Medicaid can pick up those costs. Alternatively, what I see in my practice more so is individuals who are in the nursing home qualify for Medicaid and then apply to take that benefit with them to an assisted living setting. So it's a way to jump the line for a waiver benefit by qualifying for being in a nursing home, but then converting it to waiver in a nursing home, assisted living or at home. But you still have to first meet the eligibility requirements otherwise needed at the nursing home for how we handle that.
Okay, thank you. No, there's no other questions right now, but this is great information, so.
Perfect. So if we're talking about an individual, not a married couple relationship, the eligibility requirements are a little different, but also the strategies and the tactics are going to be different. So an individual applying for Medicaid can only have up to $2,500 in countable resources as of the first day of the month in which benefits are applied for. So unlike a married couple where we can preserve and protect all of the assets, really, in an individual case, the same strategies, for instance, an annuity, are not going to be available to us. The individual can only have $2,500. This will include bank accounts, stocks, bonds, certain circumstances, the cash value of life insurance policies. So it's going to be very critical in determining what we're going to be doing in the individual situation by similar spend down options that the married couple has, including paying down debts, nursing or medical bills, pre-need funeral. But then we're going to be looking at what to do with the extra money. We're not able to give it to a spouse to protect ultimately. So our options are, I hate to say the word limited, but they're just different. So in determining what we have to spend down for both a married couple and an individual is first determining what's excluded and what's countable, because excluded resources do not need to be spent down or otherwise disposed of. So as an applicant, you're able to have one burial plot, an irrevocable pre-need funeral or cremation trust, keyword irrevocable. You can have whole life insurance if the face value is $1,500 and a cash value of less than $1,500. Anything exceeding that value would be countable. Term life insurance, if there is no cash value, the applicant can have a car and household goods and effects in the residence and the house. Now, there are different criteria of when and when not the house is countable or excludable. We'll talk about that later. But for our purposes for now, the home is also excludable. Keep in mind that when I say car, we don't want to be purchasing luxury vehicles that cost $100,000 as a quick way of spending down. There are limitations on the type of car you can have within reason. They're not strict, but we don't want to be too crafty and buying a really expensive, Cadillac right before you have to apply for Medicaid. In addition, for household effects and goods, if you do have things of significant value, jewelry that has an appraisal, antiques, fine art, china, those things may be countable and may need to be appraised and potentially sold or transferred as a way to spend down. Now, what's countable? So we've talked about excludable. In terms of countable resources, we're going to be looking at checking, savings, CDs, money markets, IRAs, stocks, bonds, cash value of life insurance if the face value is over $1,500. So again, if it's a term policy with no cash value, it's not going to affect eligibility. If it's a whole life, cash value may be accumulating over time. That cash value itself is countable, not what the death benefit or the face value is. It's the cash value of that policy. Accounts are valued at the first moment of the time of application. So if we're looking at September 1, it's 12:01 a.m. on September 1. So it's a somewhat moving target. Sometimes when you have accumulating values in assets, stocks, the market may change. So it's important to keep your finger on that pulse to make sure you're properly spent down, because if you're 1 penny over the 2,500, you're ineligible for that entire month. Now, one nice benefit of a spend down plan, that even though the first moment of that month is what you're looking at as far as balances of countable assets, there is a strategy of writing checks before the end of the month. And if a check is not yet deducted from the balance, but it eventually later clears, that's a way to spend down. So it's not as simple as just looking at a bank account and seeing, oh, they have $3,000, they're not eligible. So there are ways that we help clients navigate that by writing checks to pay bills and not having to stress about when that person's actually going to deposit that check and take that money. Now, we're looking at bank accounts of the applicant, but be careful about who's on that account. If it's the spouse and the applicant, that's considered their money jointly. Medicaid doesn't care whose it is initially, whether it's the husband, wife, or whatever, nursing home or community spouse. But be careful if you're on an account with someone else and it's their money, or someone else is on your account and it's your money. You have to be able to prove whose money it is, and the presumption is that it's yours, the applicant. So you have to prove otherwise by showing contributions, or that money is going to count against you. So if you're the child of someone who needs Medicaid and you have your parent on for convenience, maybe not the best idea, because that could count against them in their Medicaid application. All right, so how can money be protected in terms of planning options and what we're going to do to get someone qualified for Medicaid? As I mentioned earlier, the sooner you can talk to an elder law attorney, the better, because these plans can be put into motion relatively quickly. We can, under certain circumstances, get someone eligible before they even go to the nursing home. So you're not faced with that $10,000 bill. If that's not an option, either because of the timing that a client comes to us, or just because of when the calculation can be done, for a married couple, we can often get the plan implemented in a month or two, given other certain circumstances. But the sooner you come to us, the faster we're able to qualify you.
Hey, Stacey, before you get further into the information about heirs, 2 more questions. This one is actually part 2 of a question that was just asked a little bit ago. What are the needs that qualify for skilled nursing?
So that would be the needing help with at least 2 activities of daily living. So if you need hands-on assistance with dressing, bathing, that list that I shared earlier,
okay,
that would qualify you for nursing.
all right. This person writes, apparently it is not the ADL needs, which is a separate criteria, question mark. I'm not sure what that.
So I'm not sure in what specific scenario that was stated to you. What we're looking at when clients come to us is the ADL needs.
Okay.
There are other ways to qualify in addition to just straight ADLs. It's a matrix. So you're looking at either at least 2 ADLs, but you need sufficient need in accomplishing those 2 ADLs. It's not simply telling someone that you need to go eat your dinner now. It's actually needing to be helped by preparing and feeding.
Okay.
So ADLs is one way to qualify. You also can qualify by needing certain assistance with the instrumental activities of daily living and behavioral. So it's a score sheet that often I'm looking at to score, to judge whether that person needs that assistance or not. Mm-hmm. So you can meet in a variety of ways, directly by the score or how much help you need with those areas, behavioral, IADLs, and ADLs. So if you want to message me separately to ask about your specific situation, I'm happy to talk to you about that.
Okay. Another question. Is an apartment in independent living counted as excluded housing?
So there's no equity or value in an apartment. So that wouldn't be protected in the same way. No, but you'd still have that rent requirement. Right. So if your spouse is living in the apartment, they would still be required to pay that expense. But it's not a home with value. So that wouldn't qualify in the same way.
Okay. 2 more. Is there Medicaid coverage for at-home care? Does it look like this will become more available in coming years?
Good question. So that's similar in my answer about the assisted living coverage. There are circumstances where you can qualify for nursing care, apply and receive long-term care benefits, and then apply for the waiver from the nursing home and take that home. You're typically not going to be receiving 24/7 care, though. They do a separate evaluation as to what you qualify for, and then the waiver program would pick up those hours that whatever you qualify for. It's not a one-size-fits-all. Whereas a nursing home, it's more routine in terms of the room and boards covered, your doctors, et cetera. When you're taking that benefit home with you, it may or may not fit your needs. But if you're not getting coverage from long-term care benefits first in a nursing home setting, then you're looking at that very long wait list. So the answer is it depends. In terms of if it's going to change, there's been a lot of legislation in the many, many years past, and I'm assuming in the years future to change that. But as of right now, I don't know.
Okay. We've got another one. If resources must be down to $2,500 as of the first of the month of application, and the application process takes weeks or months, yet huge monthly expenses are accruing, how do you deal with the time lag before Medicaid is resolved and payments start? Excellent
question. So if we're working with the client to qualify for benefits as of September 1, we actually submit the application anytime in the month of September, so long as it's received before the last day. In that lag from September to whenever the application is approved, we advise our clients to pay that cost of care that we calculate for you based on your income and your deductions from whatever September 1 through, let's say, December. Once you get that approval dates back to September. So you get that coverage from your initial eligibility date. So then the nursing home would then apply for that coverage. So you're not going to be paying the private pay rate in the interim.
Okay. The second part of that question is, will the nursing home wait to be paid while a Medicaid application is being processed?
They absolutely will. They will also email us on a very regular basis to ask us the status, to see if things are coming along and make sure it's being processed, appropriately. Medicaid has 6 months to approve an application. If they do not by the 6th month, we always appeal for improperly handled application or because it's taking too long. On average, applications take between 1 and 4 months. It depends on the caseworker you receive and what county you're applying in. So different offices handle different parts of Maryland in terms of application eligibility. But yes, they will and they do wait. It helps to have an attorney advocating and speaking on your behalf, so you don't feel pressured or unsure about what to do. But no, I mean, most nursing homes, they completely understand about what's going on and that you've applied. Yes. So either you've told them you've applied or we've told them you've applied, and then we keep them updated.
Perfect. All right, so let's carry on with protecting our money.
Yes. All right, so there is a 5-year look-back period. You may or may not have heard of this before. When determining eligibility, it's not just the medical and the financial component of what you have on that first day and submitting an application. They also want to look back in time 5 years to see what you've done with your money. Have you gifted large sums of money to different people for purposes of spending down to that $2,500, or in a spousal case, the $130,000 plus 25 of the applicant? What have you done and how have you conducted your business? They want to make sure essentially you're not doing anything tricky just for the sole purposes of qualifying. So they're going to look back 60 months of bank statements. So if you're applying for September 1, 2021, they're going to want to see everything that happened from September 1, 2016 through the present. So when working with an attorney, they're going to ask you for a ton of information, all of your bank statements, whether an account was open during that time period, but now closed, or was open 3 years ago and now open. It has to be a complete transparency in terms of what happened and what transactions took place within this 5 years. The caseworker that is looking for any transfer of assets to anyone other than a spouse or disabled child. So if you're giving gifts to people or loaning money you haven't been yet paid back for, they want to verify that what you're doing is above board, because they don't want to give you this Medicaid benefit if you're voluntarily impoverishing yourself. Gifts that are made within this 5 years, though, how they're evaluated is for every $10,190 that's gifted. It could be the aggregate total of $10,000. It doesn't have to be $10,000 per person or per thing. Medicaid's going to penalize you 1 month of eligibility. So the penalty start date used to be when the gift was made. So if it was made 3 years ago, you wouldn't be eligible for a period of time from that date. Now it starts when you're actually applying. So if you made a gift 4 years ago, you don't get a prorated credit from it being 4 years ago. It's an all or nothing scenario. So if you're gifting 4 years ago, $10,000 to someone, then when you apply that September 1, 2021, you're now getting that penalty of 1 month, meaning the nursing home is not going to be collecting from Medicaid for the balance of that month. You're on the hook for the private pay for September, and then you otherwise could be eligible for October. So the current amount is $10,190 transferred. Just some examples for 2-month penalty, 10-month penalty. For instance, if you're actually transferring things to someone else, let's say you're giving your house to your daughter. If the house is valued at $200,000, that under the current rules, that would be a 19.63 month penalty. So by gifting that house within those 5 years, you're incurring a little more than 1.5 years of ineligibility for Medicaid benefits. So keep that in mind. The timing of these gifts are critical in evaluating your eligibility for the benefit. But by working with an elder law attorney, there are strategies we can employ to get rid of any penalized transfers, because Medicaid is not looking at just the transfer itself, but your intent. If your intent on giving this money away or these assets was not purely to qualify for Medicaid, then Medicaid's not going to penalize that transfer. You have to have the intent to do it for the purposes of receiving that benefit. So keep in mind the gifting. You'd want to be careful when you're gifting money to your children or to other family with this requirement in terms of timing. If you know there are gifts that you've made in the past 5 years, when you're coming to me, we're going to ask you about them and the circumstances. Just keep that in mind. when giving gifts, if you think Medicaid may be something you or a loved one needs in the future, and keeping good records of that, of who and why.
Stacey, another question. Can spend downs include expenses paid to children for tasks, chores, or activities that benefit you?
So yes and no. It depends is the answer. If your child is providing care for you and there's a history of that, we often implement or create an agreement between yourself and your child for a caregiver. So a caregiver contract or a restatement of a reimbursement agreement to explain why you're giving your child those funds. So in certain circumstances, yes, that is allowable, but you have to be careful that you're documenting the why and the circumstances of it, because otherwise the presumption is the money given to a child or for their needs is a penalized transfer.
Okay. Is the $10,000 gift at once or $10,000 over the 5 years collectively?
It's collectively. So we're going to add up all the gifts. So if there was, $1,000 every year, then it's $5,000 that could be penalized for half a month. It doesn't have to be all in one shot, but it's collectively. We go through all of the bank statements, add all of it up, ask you what it was, see if we can get rid of any of it. And then if we're presenting that to the caseworker, that's what we expect, that amount aggregate is penalized. Now, keep in mind that if you have a pattern of gifting, like birthday gifts, or you're paying for your child's wedding, things that are routine in your life, then there's a way of getting rid of those penalized transfers, because that's just what your habit has been. And if we can prove that and demonstrate that to the caseworker, that's another way of potentially getting rid of these gifts so they're not penalized. Now, a strategy for an individual to qualify for Medicaid is often gifting. That is a way where we can protect a sum of money for the individual applicant who can't otherwise transfer all their money to their spouse as a way of protecting it. So we'll look at what the individual applicant's money is, over $2,500, and perhaps intentionally give that to a child or another family member. That triggers that penalty. So depending on how much you're gifting, let's say $100,000 or $300,000, we're going to accept that penalty, apply for Medicaid, and then we're going to cure that penalty by returning a portion of that money. By returning a portion of that money, either to the applicant or by paying their bills, so the nursing home bills, every month for a period of time, the penalty actually gets shortened. So it's a math calculation that says, okay, I once gave $200,000 to my child for this purpose. By the child giving back $100,000, now I've only gifted $100,000 in total. So we can protect at most typically 40 to 50% of the assets, so the individual is not faced with just having to pay down debt or the nursing home for a period of time up until the point they now have $2,500. So with a spousal relationship, we can protect about 100%. With an individual, we often use this gifting strategy, intentionally creating a penalty to protect up to half of the assets. Now, there are some exempt transfers that you can have made in the past 5 years that are not going to affect eligibility to the spouse. Unlimited spousal transfers are allowed. Again, that's also why we're able to use the annuity for a spousal case. We transfer everything to the spouse in the community. If an applicant has a blind or disabled child, that also is an exempt transfer. So if in the initial meeting with you, I'm going to ask, do you have any disabled children? If the answer is yes, one of the spend down tactics may be giving everything to that disabled child. So there is no penalty at all for that gift. Or a trust established for the benefit of that disabled child. So it depends on what the disabled child's needs are as well. If they're also receiving public benefits, we don't want to disrupt their benefits for purposes of protecting and securing yours. So there are different types of trusts that we may offer to clients as a spend down option, either for themselves or their disabled spouse or child. Putting money into a special needs trust, either a standalone trust that would be created or entering into a pooled trust may be an option. that you want to implement if there aren't expenses and you don't have a family member to do that gifting plan with, either because there isn't enough money to make that useful, because there isn't enough money to protect half, let's say, or there isn't a relative that you trust or a relative at all. But trusts are often a helpful way to put that money into a exempt vehicle that would otherwise allow you to have less than $2,500, either for yourself or a spouse or disabled child.
All right, Stacey, there's a question about a disabled minor child, or does disabled adult child count?
Either. Disabled is the key issue here.
Okay.
So back to the home property and what circumstances the home can be both protected, but also whether it's countable or excludable. Okay.
Well, here's a question about the home. So at Augsburg, residents pay an entrance fee to come in. And it's an apartment, but they do pay an entrance fee. So the question is an apartment in Augsburg counted as excluded house? There is equity-like house to protect 80% of the original deposit of the entrance fee.
Okay, so previously someone asked about the apartment. So when putting in that context, that's totally different. So for continuing care communities, CCRCs, with an entrance deposit, that depends on if the facility will elicit such a statement that says that that money is non-refundable. If the resident has access to that money where they could ask for some of it back, or if when they move, they get it back and it's otherwise accessible to them, that's going to be countable. If it's not accessible to them and the Augsburg or another CCRC says that it's unavailable to them, then that money can be protected just like a house.
Okay, so Augsburg's entrance fee is refundable.
Yeah, so we would talk to the CCRC about what we can do in terms of a statement to make that unavailable. But if it is available, then that's going to be a countable resource. So then it depends on how much the deposit's for.
Okay.
So the home is excluded if the following are met. The applicant has immediately resided there prior to the entrance into the nursing home. The applicant intends to return home. This is a subjective intent. It doesn't mean you actually are able to ever return home. It's just a question on the application. Yes, I intend to return home. And if the equity interest is no greater than $603,000. This number, the 603, also is one of those numbers that changes annually, sometimes less frequently. So as well as those criteria, the spouse living in the home also makes it exempt. So if you're a married couple, your spouse is living in the home, independent of your intent to return home, then it will be exempt while the spouse is living there. But that's important to note, because if your spouse is living there and they predecease you, what are other tools and tactics to make sure that the house is protected? So that's where your intent to return home enables that asset to be protected. So you can maintain and keep your Medicaid benefit. You're able to transfer your home to your spouse, your blind or disabled child, or a child under 21. This is a strategy that we often implement in getting the house out of your name if you're applying for Medicaid. It's not something that's going to disqualify you for eligibility purposes, but we don't want the house to be in your name alone when you pass away. Medicaid's able to put a lien on the house up to the amount that they've paid on your behalf. So if they paid $7,000 a month forever, then that lien can increase by $7,000 every month, and that would have to be paid off when the house is sold. Alternatively, Medicaid could also file a claim in your probate estate. If the house is just in your name when you pass away, then the house would theoretically need to be sold to satisfy that claim if it's higher than someone in the family can afford just to write them a check for. You can also transfer a house to a sibling who has an equity interest in the home. So if you own a house jointly with your brother, if the sibling has resided there for at least 1 year prior to your institutionalization. Another way to protect the house and transfer it to somebody else without penalty is if a child has cared for the applicant the 2 years prior to institutionalization. So ways to document this is by a doctor stating that you otherwise would have needed long-term care, but not for your child moving in to help take care of you. It has to be for the entire 24-month period. So it's important to have this, if possible, documented immediately. So you're not having to look retrospectively and have the doctor, maybe who doesn't know what your situation and care needs were back then, create a statement. Proof that your child either quit their job to take care of you or put you in a situation where you receive the care that you need. They coordinated adult daycare or caregivers coming into the home. And then proof that the child actually lived there. So their utility bills are coming to the house. They're potentially paying part of the utility expenses or the mortgage or paying rent to you, something of that nature to prove they actually live there. So as I mentioned before, Medicaid can put a lien on your property. So if possible, to get the property out of your name, it's strongly advised. So like I said, you can own the home and be eligible for Medicaid, but you don't want to own it by yourself when you pass away, because then it's subject to a claim. Now, there are certain situations where a lien can either be removed or not be allowed to be placed. If the home is lived in by an unmarried child under 21, a blind or disabled child resides in the home, or that sibling lives in the home with an equity interest, so it automatically passes to them by joint ownership, let's say, or the spouse is residing in the home. So if the home is owned between both spouses, the nursing home spouse and the community spouse, and you haven't removed it from the nursing home spouse's name, if the spouse is still living there when you pass away, if you're the actual recipient of the benefit, Medicaid cannot put a lien on the home. But that's something, if it's possible to avoid, you'd like to avoid, or you're not really protecting that asset. So if it's important to the family to keep the home itself and not just the equity in it, then it's helpful to talk to an attorney about what strategies can be implemented to protect it to the extent possible. In a gift and return plan that we talked about, where you're intentionally creating a penalty, we may talk to you about is the goal to keep the home protected or the cash. If the goal is to protect the home, then we may put it into a life estate to have it passed directly to a family member, let's say, but then use the cash to pay during that penalty period if the cash is sufficient enough to have available to pay the nursing home during that period where you're penalized for otherwise gifting it to somebody else. So there are ways we can kind of juggle what the priorities are with what the options are, depending on what the goals of the family are. So there are two different types of life estates that my office would talk to you about in terms of protecting the property. You may have heard of this before. Medicaid will consider a life estate with the power of sale, meaning you own it and you are able to dispose of it at your leisure as a countable asset. So it's important to know how the title to the property is held in terms of what we can do to help protect that property and how Medicaid is going to view it. A life estate without the power of sale, meaning that if I own it, I'm not able to encumber it with a mortgage or sell it without permission of the people who I've left it to upon my passing. Medicaid's going to consider that a penalized transfer. So in terms of pre-planning and strategy, if you come to my office completely healthy and well, I may offer to you creating a life estate without power with the hope and expectation that you're not going to need Medicaid for at least 5 years to hopefully outlast that look back period. Anything that happened before those 5 years that we talked about, Medicaid can't consider. They're not going to know about. So if you do a life estate without power today and you don't need Medicaid till 2030, that's now completely protected. Medicaid's not going to penalize that transfer of that home. Whereas if you do a life estate with the power of sale, it's the full value is countable. So how you title your property and when you title your property is key in protecting certain assets. After you've applied and received benefits in a spousal case, Estate planning is going to be crucial in making sure that the nursing home spouse's benefit continues to be protected and not jeopardized. As part of our planning, we will discuss what estate documents you have and what you may need to make sure that in the event the spouse in the community passes first, that money that we've now protected by giving everything to them is not going to now go back to the nursing home spouse. We don't want to now have them have a windfall where everything we did to qualify them for benefits is now disrupted. So we want to update your will, your power of attorney for both spouses, potentially, if they have the capacity to do so, to protect that benefit. Everything we're doing, all the time we're spending, we want to make sure is preserved to the extent possible. Spouses have a right to take a share of their deceased spouse's estate. So we want to protect that by potentially creating testamentary special needs trusts within a will of a community spouse and or the nursing home spouse to the extent they're able to. These are types of asset protection that you could come to us now, even if you don't need Medicaid now, to make sure you're set up, because capacity, is fluid. You may have capacity today, but when you need Medicaid, you no longer have it. So these are types of things that we can do in the now and later, depending on capacity. Now, all these things I've been talking about in terms of gifting and transferring assets, this is going to be limited to the power that that individual has. If you're the nursing home applicant and you have capacity to sign over your deed or transfer your checking account to your spouse or to your child, then we're going to be using you to be part of the plan. Alternatively, if your power of attorney, if you have one, is able to do it on your behalf, if you don't have capacity, you have to be very, very careful in what powers are in that document. If the document does not enable that person to make those gifts for you, then you cannot make those gifts at all. You would have to get court intervention, which I believe Rachel talked about last week in terms of guardianship or other types of legal court processes that would require, one, it's a lot more expensive, time consuming. It's up to the judge to ultimately decide whether that power is going to be granted or not. But updating your documents, both pre-eligibility and post-eligibility, will give yourself and your spouse or your loved one more powers and options when it comes to these spend down tools.
Plan. That's the key. Plan.
Yeah, because oftentimes when you're entering the nursing home, it wasn't something you thought about 2 years ago. You could have had a stroke and you're all of a sudden now faced with this huge burden of having to, deal with the fallout, whether it's your child or your spouse. What are they going to do? And if they come to us and the power of attorney is not sufficient, we're looking at other options in terms of the court. So there are some things you can do now to pre-plan and some things that you're going to be looking at in that moment. But after we apply for Medicaid, we've accomplished and received that benefit and we've been approved for it. Certainly in a spousal relationship, especially, we want to make sure that that is put into place. So all that money is not going to go back to the nursing home spouse and disqualify them. So then someone else has to then requalify them in the future. So quick summary. So the medical and financial components are just outlined very briefly. For medical, the hands-on assistance, Intelligent ultimately rubber stamps it and says yes or no, whether you're eligible. And the financial, it will greatly depend on whether it's a married couple or an individual as far as what can both be kept and protected. The 5-year look back, extremely important. If you're able to keep good records now in the event this should ever come up, hopefully it doesn't, but if it does, gathering all that documentation to either give to your attorney or to the Medicaid caseworker is going to be a big burden. So if you're able to keep good records or have online access to your accounts, it goes a very long way. Looking at what assets are countable or excludable, and then what it's comprised of. So these are all key points to keep in mind when determining either yourself and or with your attorney what the best plan is for you, because it's not a one size fits all. We're going to look very carefully at your individual situation and what your goals are in terms of protecting assets. So that wraps up my presentation. If you have any more questions, please feel free to ask.
I do have a few extra questions, Stacey. So for a single person, what is the impact if you have beneficiaries i.e. children, on your bank accounts versus joint accounts, assets for eligibility and or for spend down medical care?
Okay. So an individual still can only have the $2,500. So if you're joint on, let's say, your child's account and it's their money, not yours, that balance could affect your eligibility, because let's say they have $10,000. So you're going to have to document very carefully that it's your child's money and not yours. And then you're going to have your name removed from that account, because even though you say it's not your money, it eventually has to not be your money. The only amount you can keep is the $2,500. So joint accounts can be tricky in that way. But beneficiaries on accounts, not a bad idea if it's an individual situation, because Medicaid can't collect from a claim on your estate if there is no estate. So for an individual, having beneficiaries on the account's a good thing, or a convenience owner. Like, let's say your child, they have no money in the account, but if they're on your account, it'll pass directly to them when you pass away. So even if Medicaid had a $50,000 claim saying they're entitled to that money, they can only collect from the probate estate. So if the probate estate's zero, they can collect zero. That's very different from a spousal relationship in terms of an application, because the spouse is entitled to the benefit of the other spouse's money. So I don't advise having beneficiaries on accounts of the community spouse, because you want money to pass through probate to fund a special needs trust, which I can talk to you more in detail. It's a whole other presentation. So an individual, yes to beneficiaries. Joint owners can be tricky depending on the situation that's presented. But for a couple, you probably want things to go through probate.
Okay. Another question. Is state partnership still in effect for long-term care insurance?
I don't know.
Okay.
Not super familiar with long-term care insurance and those. I don't know.
Thank you. Another question.
Sorry.
What is the cost of an attorney to handle Medicaid application? Please give examples or range if it varies greatly.
So that's a tough one to answer. It depends on if it's an individual or a spousal relationship, or if they need to go to court to get some interventions that the power of attorney does not provide for sufficient planning and options.
This person asks, assume no spouse and simple assets. Obviously, it's a situation without much money available.
Yeah, I mean, it's not a flat fee in my office typically, but we work with clients depending on what their needs are and their resources that are available. Legal fees are an allowable spend down option in terms of what you're able to pay to get down to the $2,500. I'd rather talk to you individually about what your situation was. I mean, it could be several $1,000s or more. You're not going to be, I mean, we're not going to take all your money as purpose for spend down, but it's going to be, you know, a few thousand or more, depending on what your circumstances. And again, it's not a flat fee. So we work with the client to make sure that they can pay that and that it works into the plan.
And Augsburg does have a social worker here that can assist with, you know, Medicaid applications. Quite often we do recommend that families speak with an elder law attorney, especially if it gets very detailed. We may not, I'm sorry, I turned myself off. We may not be able to go into too much detail, but we do have a social worker here, and we have someone in our finance office that helps families with Medicaid applications.
Yeah, if your assets are already at such a limit that you already are close to or eligible for Medicaid financially, then working with the facility themselves may be the best option for you. Social workers can't give legal advice as far as spend down strategies. So it depends on what you have and how much you have. But a consultation with an attorney could be a good option, because we're not going to take your case if it's not appropriate. So it depends on what you have, and if there's prior gifting that we have to explain, or we're doing a gifting strategy, that's when you'd want an attorney. So it just depends on what there is and what the needs are of the family.
Well, Stacey, thank you so much for this presentation. It was probably one of the most concise and well presented on this topic that I've seen. It was easy to understand, at least from my perspective, compared to some that I've seen. And I think that you explained everything, you know, very well and thoroughly. So thank you again for answering all the questions. I'm so glad that we had the audience, you know, jump in with their questions. And as I mentioned at the beginning, we will have this recording available on our YouTube channel, and Adrian will be sending out a link to you all so that you can watch it again at your convenience. And then in 2 weeks, we have part 3 of our series. And Alex Zarzecki, who is actually Stacey's colleague, is going to be talking about probate, which is a fun topic. And then, so that's on September 9th. And then on September 24th, we are wrapping up with a discussion about Medicare. So if you haven't registered for either of those, you will have an opportunity to do so. There's links on our website. You'll get an email also. So look for those to come. And again, thank you very much to Stacey for your time this afternoon, and to everybody who joined us. I hope you learned a lot, and any questions that you have, please feel free to reach out to Stacey directly. Her information is here with you, and I hope you do take advantage of her expertise. Thank you for joining us. Have a great rest of your day, a wonderful weekend ahead, and we will see you hopefully in a few weeks. Thanks, Stacey.
Thank you, everybody.
Bye-bye.
Take care.